number one, I'd like to give the Director Brown an opportunity to read this opinion, but in light of some of the procedural questions and potential legalities that have been raised by Mr. Ottilie, I'd like to ask our counsel, Helen Peake, just to opine as to some of the assertions, whether or not, I mean, my sense is, if I was getting in trouble when I wear my legal hat, there'd be nothing in the staff report that precludes from taking action today, but I'm curious to get your views.
I don't believe that there is anything that precludes your taking action today. We are not counsel for CCDC in the action that's continuing. The action that we were handling on behalf of CCDC, we actually demurred successfully, and CCDC is out. City Attorney's Office is handling the defense of CCDC in the pending action. But the fact remains that there are two legal opinions that indicated that the project could be processed, and in the absence of a court order, I believe that due process would indicate that you do need to process those applications. That's CCDC's job. It is the developer's risk in the event that the decision is adverse to the development of that property for the period of time that the plaintiffs suggest. And we do not have any kind of injunction or court order prohibiting or preventing any action from being taken by this body with respect to the applications that are before you.
And that would be the typical course of affairs. There would be some action by the court to suspend our actions until there have been some determination by the court. That's not
unheard of for an injunction to be issued, but there is no such injunction.
And in fact, the court ruled in favor. It would have the effect, I gather, of undoing whatever approvals or determination was made and nothing was having to say.
It would at least hold the matter in abeyance or status quo, certainly. But we don't have that in this case.
Thank you. We can move on to any questions of staff, or then no questions.
Comments. I have a question of staff. Counsel. I just have a question. If we were to agree that the appropriate action today would be to stay or to delay ruling until there's a court decision, let's just say that's a hypothetical that we wanted to entertain. What if at the end of the day that the applicants here in the that have spoken up against the project end up being wrong? Is there any kind of damage that can be assessed against the applicants because of the delay of the project?
Assessed as against the applicants? Or
yes, I mean against the people that are opposing. In other words, if indeed it's being suggested that our best action in light of not having injunctive relief because there's a viable lawsuit, that we should delay this project until there's an ultimate termination in this lawsuit.
That responsibility would not lie with the opponents of that litigation or that project. As the owners of the deep pockets, I would assume that the developer's action would be as against the agencies.
Let me ask, I also have a couple of questions of Mr. Ottilie. And I apologize, I know you indicated repeatedly that you were litigation counsel, but perhaps you could entertain these questions for me if you could. Has there been any injunctive relief action brought in this matter that is case number GIC 873710?
Not that I'm aware of. I'm looking at Mr. Burns.
We've been advised that
Wait.
Don't tell us what your lawyer told you.
Maybe I'll be litigation counsel for a second. Apparently not. So there's been no one way or the other on injunctive relief. But it's not that it's been sought and denied. It hasn't been sought. My understanding, they would correct me if I was in here.
Okay. And is there any cause of action in the current complaint that seeks injunctive relief as part of the damages or the prayer for relief?
I believe so.
I believe so.
Okay.
Well, that would be the nature of it. You would seek. You can seek a restraining order, preliminary injunction, or permanent injunction. There's a much higher burden of proof, as you all know, to get a restraining order or a preliminary injunction. The majority of lawsuits I file these days in the election context or sports context have a cause of action for injunction, but we always just delay until the permanent injunction, because you then have the normal burden of proof in a civil action as opposed to an artificially high burden of proof that's imposed in a restraining order, or a higher burden of proof in a hearing on a preliminary injunction.
And in light of that higher burden of proof, and there has been no application on behalf of the plaintiffs in the case to seek that to prevent this project from moving forward, correct?
Yeah,
that is a leading question, isn't it? I'm going to ask it another way.
I believe he said that is part of the relief that is being sought in the case in chief. It is simply that there has been no application for
to do so.
preliminary or intermediate relief.
All right.
And I guess our concern is that you get into a Sunroad situation where you allow things to get out of the barn, the horses out in the field, and then you're trying to tear down a building. And having been through that once, we don't want to put the citizenry through that again. So the folks that had an opportunity there to stop Sunroad actually didn't even consider it. They shifted it completely over to staff, which was an abdication of their responsibilities. And now we end up with something that could cost the city millions of dollars because the city didn't delay. So somebody asked the question, I think it was you, Ms. Brown, as to what if the applicant turns out to prevail in that suit, what about damages? Let me throw back the issue on the other side. What if we pull a Sunroad and it turns out these folks were right, and then you've got damages because you've allowed somebody to build and they're coming back on you like the folks at Sunroad are?
Well, let me throw another question out for you in that regard. Given that I suspect Judge Nevitt, in his experience, has heard of such matters, why don't we have an injunction from that judge directing us not to proceed with this development?
Well, you don't, because the judge can't act, as you know, absent a request for that. The judge can't essentially assert his TRO. As Ms. Brown would tell you, and Ms. Peake will as well, your agency has had the opportunity since the commencement of this lawsuit to initiate your own debt relief action. So I guess the question I would have, again, not being familiar with the litigation, Mr. Chair, is has your organization a year ago, when you realized there was a potential for this issue to arise, which is whether the applicant might be damaged by a delay, or whether we might face a Sunroad by going forward and having to undo it, did your organization, either directly or through the City of San Diego, seek a declaratory relief action, which is entitled to preference on the court's calendar? You can seek preference, and within a matter of months, you could get a declaration of rights under this AARP from Judge Nevitt and resolve the issues so that potentially nobody's damaged. That'd be my recommendation if I had been advising you at the time. I think that just makes sense, because that way you protect yourself. Ms. Brown knows that.